We began by saying that the court delineated a general right to privacy in Griswold v. Connecticut in 1965. I like to think of the right to privacy as an umbrella right, where the question becomes what specific activities or actions undertaken by individuals have constitutional protection. We know that individuals have the right to use contraceptives. We know that women have a right to terminate their pregnancies qualified by the viability standard. What about sexual practices? In Bowers v. Hardwick in 1986, the Supreme Court held that it could find no constitutional protection for sexual preference. However, in 2003, the Supreme Court reversed in Lawrence and Garner v. Texas, striking down a Texas law criminalizing same-sex sodomy. The court held that the state had no interest compelling enough to warrant intruding into the personal private lives of citizens. Right to die advocates contend that the right to die question is fundamentally a private matter. However, the Supreme Court has not taken up the question directly, so we do not have a definitive answer as to whether the Constitution protects a right to die. The court has addressed some peripheral issues, such as the validity of living wills, which the court upheld in the Cruzon case. Other courts have decided cases which restrict the authority of states to interfere in cases involving patients in a comatose vegetative condition, generally holding that in the absence of express wishes by the patient, the decision whether to continue life support devolves to the next of kin. The State Supreme Court of New Jersey upheld this principle in two cases, Enri Quinlan and Enri Conroy, in which parents had battled with state officials to have life support discontinued. In the Terry Schiavo case of 2005, the husband of Mrs. Schiavo won numerous court decisions against Terry Schiavo's parents, who were allied with Florida's Governor Jeb Bush and other state officials in an effort to prevent Terry Schiavo's husband from discontinuing life support. The courts consistently held that the husband had the final decision-making authority as next of kin. Finally, how much authority do employers have to monitor the email correspondences, telephone calls, and other activities of their employees while at work? Again, we have no definitive answer from the United States Supreme Court, but lower courts consistently appear to be willing to give employers, particularly employers in the private sector, considerable discretion. There are numerous other potential right to privacy questions that may be looming in the years to come. Medical patients' privacy, educational records privacy, and internet privacy, to name but a few.